How do I see who was on here? That way, I don't want to waste our time with if
You can.
Okay, I can see participants. Okay. All right, we're ready.
Gonna give everyone a few minutes, maybe 2 or 3 minutes to
Okay, I ain't sure.
log in.
We got time.
Okay.
I mean, we could actually start at like 10:35 because I mean I don't think it may not last the I don't know if we're gonna.
Okay. So we're gonna start at 10:35.
Okay.
Okay. For those of you just joining, we are going to start at 10:35.
Got like a minute left, Marla, and we could start. You got any announcements to make or anything, Marla? Or are we just starting getting into it? Marla? Hello? Hey, Marla, you want to just go ahead and start?
Yeah, we can start at 10:35. Give me a second. I'm on the telephone with some.
Okay, my bad. What the heck?
Okay, good morning, everyone. Thank you all for joining us for the second session of our end of year CLE. Today we have Attorney Harry Daniels, who will be presenting to us on criminal law updates for 2020 and talk to us about the practice of criminal law. Thank you, Attorney Daniels, and take it away.
Good morning, everyone. We're going to go ahead and do some criminal law updates. 2020 has kind of been a weird year as far as updates, both from, I guess, from a legislative standpoint, also from a appellate standpoint. So I think what I've done is I've kind of built a lot around the most important thing I think that happened this year as far as criminal law was us getting the Ramos decision, which allows unanimous verdicts here in Louisiana. So we'll go ahead and get started. If anyone has a question at any point, please feel free to put in the Q&A or the chat box. I think, Marla, if somebody posts a question at any point, just read it out to me. I think that'll probably be best to do it then, as opposed to kind of waiting to the end.
Will do. All
right. So Ramos and 12 angry men and women. Louisiana, this last year, I think 2019, we passed a law, a constitutional amendment that allowed us to have unanimous jury verdicts. Well, the problem was that only affected the cases moving forward. That started January 1st, 2019. So it didn't affect any cases that had been pending or that had been decided or even that was on appeal. So that's where Ramos comes in at. In Ramos versus Louisiana, the United States Supreme Court ruled that we can now have a non-unanimous verdict violates the 6th and the 14th Amendment of the Constitution. So that now gives us, in any case that's currently pending or that was on appeal, that gives us non-unanimous jury verdicts. The Ramos decision was big because that basically may give a bunch of people new trials. The Ramos decision applies to all defendants whose cases are still pending on direct appeal, and possibly cases that preserve the non-unanimous jury verdict pre-trial or post-trial. And when I say preserve the issue post-trial or pre-trial, that was when some lawyers prior to trying the case, prior to this decision, would file a motion moving to declare the non-unanimous jury verdict unconstitutional. And pretty much every case except a few cases, there's one case in Sabine where a judge actually ruled that it was unconstitutional. And he also had the Ramos decision out of New Orleans where some judges had actually ruled that it was unconstitutional. But in most cases, it was just an objection that you would raise pre-trial, or in some cases where the verdict was rendered by a jury, either 10-2 verdict or 11-1 jury verdict. People would then make an objection to preserve the record as far as a non-unanimous jury verdict. However, the Ramos decision, the justices in that case, actually, they didn't go as far as we would have liked in that case. They didn't apply it to any cases that, what they say, cases that's on collateral review. And when I say collateral review, that means a case that's on post-conviction, whether it be state post-conviction, where you're inside that 2-year window when you can file your state post-conviction application, or you're outside that post-conviction 2-year post-conviction window. They didn't apply it to those cases. Well, there was some good language in the dissents where some of the justices seemed to indicate they may go a step further, but they wasn't prepared at that time because they said it would be what's called a watershed rule. And while it didn't apply to post-conviction cases, that may change pretty much in the next 4 to 6 months. On last week, an attorney out of Baton Rouge, Andre Bellangio, he actually argued Edwards versus Vanoy, where he argued that the Ramos decision, the non-unanimous jury issue, should also apply to post-conviction cases. And if that appeal is successful, the United States Supreme Court will have maybe about 1,500 people that can possibly get new trials or get reductions of sentencing as a result of the Ramos decision and the non-unanimous jury verdict being deemed unconstitutional. So that's something to look out for. Probably mid 2021. I think the Ramos case was argued last April, and it didn't come out for a while. It came out in March. So you can look maybe 4 to 6 months down the road. Edward versus Vanoy, we should have a decision there, and hopefully it will grant those people on post-conviction or collateral review the opportunity to challenge their sentence, a non-unanimous jury verdict sentence. Well, there are several Ramos-related issues that I think you have to be aware of. Ramos is kind of an issue that while it grants some people new trials, once they get that new trial, there may be several issues that you have to be prepared to litigate, whether you're a prosecutor or whether you're a criminal defense attorney, and whether or not you get one of these cases. So one issue you have to be on the lookout for is what's called a Batson claim. Batson versus Kentucky is a case that says that you can't discriminate against a juror because of race. You can't just single out a juror. And that was kind of why we had the non-unanimous jury verdict was a big issue for us, because a lot of times you would have those 10 to 2 verdicts and those 11-1 verdicts where you would isolate what some would say the minority in a jury room. And you basically said their vote was meaningless and it wasn't important. So you have to be on the lookout for raising a Batson issue in a post-Ramos era. Batson, in his progeny, basically says that the Constitution forbids the striking of even a single prospective juror for a discriminatory purpose. And that sometimes is a higher standard you have to meet, but you have to develop your record to preserve the record for appellate review, because most times you may not win it at the trial court level. I've had well over 50 trials, and I've raised Batson in at least half of those trials, and I've only been able to get a Batson challenge granted during the trial or doing jury selection in one trial. So that's a pretty low standard. My opinion, when you raise a Batson challenge, you're basically asking the court to say that the prosecution is doing something racist, or basically singling out the prosecutor as being a racist, which, is a very, I guess, a delicate issue that you have to be aware of, but you have to raise that issue whether you make the prosecutor upset or not. So that's something that you have to do. And even if the prosecutor says, well, I'm only doing it to that one juror, you can actually raise Batson after the first strike of any minority and start making your claim and making your record as to why you think the prosecutor is being exercising his peremptory challenge in a discriminatory fashion. To raise a Batson claim, there's a 3-step analysis that you have to raise. First, you have to make a prima facie showing that it's a discriminatory use in the strike. So typically, when you have a jury veneer, you're conducting voir dire after the court has did their initial questioning of the jurors, and then the state has been given an opportunity, and then the defendant has been given an opportunity. The court asks you, you do your challenges for cause, and challenges for cause is different from a peremptory challenge, because cause just means the person can't follow the law, or refuses to follow law. There's some reason this person should be struck for cause. When you use a peremptory strike, you're striking a person, for reasons that has to be for a non-discriminatory reason. Maybe you didn't like the way the person asked the question, but it can't be a strike based on race. So first you have to make that showing. So typically how you make that showing is you have to look at your jury panel and look at what the prosecutor has done in the use of his strikes, and you make that showing. So let's say if there's 4 African-American jurors and the prosecutor has struck all 4, you may want to start making that challenge at some point to point out that the manner in which the prosecutor is using those strikes he's using them in a discriminatory purpose. At that point, then the burden shifts to the opposing counsel, which I'm talking from a criminal defense standpoint. It shifts to the prosecutor to articulate a gender or race neutral reason why they use the strike. So Batson not only applies to race, but it also applies to gender. So you have to be on the lookout for that. So if you have a case where, let's say it's a rape case and the prosecutor, you believe the prosecutor is being discriminatory and striking all the males because he wants an all-female jury to, identify with the complaining witness, you have to also make that challenge. So the prosecutor then has to articulate a reason that's race or gender neutral and explain his strike, and that has to be put on the record. Then the court must then determine whether the party has carried the burden. So then it shifts back to you to show why the prosecutor's explanation is a pretext, or is basically what he's saying isn't true. So that requires a lot of groundwork when you're conducting jury selection. So I would suggest that if you're conducting a jury trial, it's probably not a good idea to be conducting a jury trial alone. So you basically want to be present during the jury selection so that you ask the questions, and you also have, what I like to say, you have at least 1 to 2 other people. You have one person marking down the questions that was directed toward individual jurors. You definitely want to record the race and the gender of the jurors, the potential jurors during jury selection, so to enable you to make this challenge. Because if you don't have that information, you're probably going to be in trouble when you're trying to make it, and you may not carry your burden, or the state may get away with giving a reason. Well, this rule applies both ways. So it's just not something that the defendant can raise. There's also what's called reverse Batson. So the criminal defense attorney must also be aware of and not use his discriminatory strikes in a discriminatory fashion. So when you're asking your questions or you're using your strikes, you have to make sure that you're not using them in a discriminatory fashion. And that's really important in the post-Ramos era, in my opinion. And this just goes back into the, how you raise the Batson claim. And a lot of times, like I said, you have to have someone assisting you in paying attention how a prosecutor is asking questions, or maybe he's directing certain questions to certain people based on race, gender, or what have you, because he wants to strike them, or maybe he develops a pattern of strikes, or his questions are targeted toward a certain race or a certain gender. So it's important that you, in my opinion, that you have someone assist you during jury selection to raise this claim effectively. Now, you may not, like I stated earlier, you may not win at the trial court level, but it's important to develop your record so the appellate court, whatever circuit you're in, that they have an opportunity to review it to make sure the judge ruled fairly. And it can happen. There's a recent Supreme Court case, I think, that came out in 2018 or 19, where a client that actually had got 100 years after a trial, but the Louisiana Supreme Court overturned his conviction, where the judge we had moved to remove somebody, and we raised the Batson challenge, and then the state did reverse Batson. And the judge granted the state's reverse Batson against me, but denied my Batson claim. And the Supreme Court in that case said that the judge had improperly shifted the burden to me when I initially had raised the claim. And my client, ultimately, he's waiting on a new trial now. So it's important that you raise these claims. Also dealing with Ramos is double jeopardy. And we all, I guess, we're all, as criminal defense lawyers or prosecutors or people participating in the criminal defense, we've all heard that phrase, double jeopardy. And as it applies to Ramos, we can make the argument that the Constitution forbids that the state from if you're successful on appeal, which Ramos, if you get a new trial, that means you are successful in getting a new trial. The state can't punish you more severe, can't come with a more severe offense from which you were originally convicted of. So that means if, let's say, the state originally indicted your client for manslaughter, they can't come back and say, well, you got a new trial under Ramos, a 10-2 verdict or 11-1 verdict. Now we're not going for the manslaughter anymore. We're going to go take your client back to grand jury and try to indict him for first or second degree murder. There's some case law out there, some pretty old cases, but I think they still apply in light of Ramos to say that the state cannot do that. I think there was one case I read where somebody had went to trial, and there's an older case where the person that went to trial, I believe they had initially charged them with a misdemeanor simple battery. The person was successful in getting their conviction, that simple battery conviction overturned, and the state tried to bring, I think, second degree battery charges in Louisiana Supreme Court case. They said that was improper. The state couldn't bring it. Jeopardy had attached because it was the same set of facts. So you have to be on the lookout for that. There's also Ramos and Collateral Estoppel. Collateral Estoppel is a little different. And it also kind of comes in within the double jeopardy, but it basically says that the Fifth and 14th Amendment prohibits the relitigation of an issue of ultimate fact that was previously decided in the defendant's favor. One example is, let's say a person is indicted for manslaughter, not because of heat of passion, but when the state alleges that the person committed another felony. And I'll give you an example of the Collateral Estoppel rule, and I have a motion if anyone wants to see it. I had a client where we went to trial on manslaughter. Client was originally indicted for manslaughter and aggravated obstruction of a public passage. We went to trial, and the morning before we started the trial, before we started beginning jury selection, the state decided to dismiss the aggravated obstruction of a public highway, and they intended to use that evidence to say that my client committed manslaughter, among other felonies and misdemeanors that they alleged. Well, after trial, my client was convicted 10-2, not of manslaughter, but of negligent homicide. Client was sentenced, and then this Ramos decision came down. And once we were granted a new trial by the Third Circuit, the state filed a bill of information saying that they was going forward on the negligent homicide and this time on the aggravated obstruction of a public highway or public passage. Well, I filed a motion on the grounds of Collateral Estoppel, arguing that the jury had heard all those facts. In order to get to a manslaughter, the jury would have to find that my client committed an aggravated obstruction of a public highway, and the jury rejected that when they reached a verdict of negligent homicide. Well, at the trial court level, and basically you have to go through the entire court record to show how that issue was already litigated and decided. So in my case, I basically itemized every part where the prosecutor mentioned aggravated obstruction. And I went through it in the trial court. He actually granted my motion, indicating that, that issue had already been decided, that the issue of aggravated obstruction of a public highway had been rejected by the jury. That's why they came back with a responsive verdict of negligent homicide. And that we were able to keep my client from doing it. Now the state has taken a writ, but there's case law, and I could give you a copy of the motion and the support documents that I use in filing that Collateral Estoppel. Collateral Estoppel actually had got that idea from a death penalty case and just used it once the Ramos decision came out. Also, since the Ramos decision, the state cannot try your client for the most severe charge if the jury returned a responsive verdict of a lesser crime. And a good example of that is let's say your client was charged with first or second degree murder, and the jury came back with a responsive verdict of, let's say, manslaughter or negligent homicide. The double jeopardy argument, in my opinion, attaches because now the jury has already litigated that issue, and the jury rejected the state's version of whether a first or second degree murder occurring. So they can't now say, okay, well, you get a new trial, we're going to take you back to where you started. So if they came back with a responsive verdict, double jeopardy has attached under State versus Jackson. So you go through that analysis, and just the state can only take your client to court and trial for the responsive verdict. There may be some other charges, ancillary charges, or charges that they didn't charge him with that they may charge, but you have a double jeopardy argument that they can't go back with a more severe charge when the jury has returned a responsive verdict 10-2 or 11-1 on that issue. There's also some Ramos and new trial and sentencing issues that I think is important that you need to know. I think we're going to see a lot of these Ramos cases in 2021, maybe 2022, once we start trying cases again after COVID. But there's also sentencing issues that's tied into Ramos. So in State versus Jackson, basically, the court there said that a defendant, if he's successful on appeal, the state can't come later and say, if you get a new trial, the court or the state cannot, give you a more severe sentence. So there's some arguments there that the state or the court can't be vindictive because you got a new trial. And how that would occur is that if a person was granted a new trial, and let's say in my case, let's say my client who was convicted of negligent homicide, he got a new trial. We go to trial on the negligent homicide again, and in that case, he got a sentence of probation. Let's say we try the case a second time, the court can't now come in and say, well, you tried that case a second time, so now we're going to give you we're going to actually sentence you to 5 years in prison because, you wasted our time or you clogged up our docket taking this case to trial. So State versus Jackson is an important case under Ramos, which you're going to see a lot of these issues, and you can make this argument. The only, it just says that the court can't be vindictive. So it's not an automatic rule, but the court would definitely have to make some kind of finding that something was not knowing, some objective finding or some objective information as to why the sentence has changed from the first trial to the second trial. So let's say your client went to trial, 10-2 verdict on a manslaughter case, and your client was sentenced to 15 to 20 years. Your client conviction gets overturned under Ramos, and you move for a new trial, and your client goes to trial a second time and he's convicted. And after a trial, this State versus Jackson says now that, they can't just say, oh, well, we're going to give you 40 years now. They're going to have to be some objective findings. And I would probably make the argument that the court has heard the evidence the first time in the first trial, and the sentence that he gave was appropriate the first time, but your client conviction got overturned because it was non-unanimous, that the sentence shouldn't go up. So, the court has to make a record of it, and you need to be prepared to make that objection if the court or the state seeks to enhance your client's sentence, or even if the prosecutor just be aware of it. If the prosecutor tries to threaten your client and says, well, if he goes to trial for a second manslaughter trial, I'm going to ask the court to give him 40 years. Just be aware of that there's some arguments to say that, well, that's basically you're being vindictive and you're trying to punish my client for exercising his appellate rights, and the Constitution forbids that. So that may, back the prosecutor down, or just to be aware of it, to rest your clients, put your client's nerve at ease that, you're not going to get a more severe sentence if you exercise your right for appellate review. as I said earlier, I think 2020 has been one of those crazy years where we also, on top of having Ramos and getting a lot of new trials, we also have COVID-related issues. What some courts, I think now, we were kind of shut down until January. We weren't having jury trials. And then once we opened back up, some courts were trying to have jury trials. And there was a lot of COVID-related issues that needed to be addressed. A few issues that I've noticed and I've been prepared to litigate is what's important is doing jury selection. Who is going to show up to jury selection? Who is not showing up to jury selection and why they're not showing up to jury selection. I think it's important that if a judge during this COVID era, why COVID is, bearing down on us and preventing certain people from coming to jury selection, we have to be aware and prepared to make these arguments. One thing I've asked the court to do in a trial I had scheduled recently was ask the court to send out a questionnaire. And in that case, it was just 4 questions, but it gave me a wealth of information, and it provided me some guiding posts that I can make arguments, and I was able to actually not have to be forced to go to a jury trial under COVID conditions because there's so many issues related to it, whether or not, your client has to wear a mask. I would say if my client's going to trial, I want the jury to see my clients. One issue I had was that, prior to, I informed the court that I wouldn't allow my client to sit in the jury trial with a mask on. I think that's your client has a constitutional right not to wear a mask in court. And there's some case law on that, not out of Louisiana, but there's some federal case law and also some case law on it out of New York. And I'll be happy to share that with you if you want it at the end of this. So I'll give you an example of the questionnaire here. Let's see. If I can get my mouse over there. So this is from a federal case, and I actually got this from a CLE that I went to, but it was important, some of these questions that you may want to just develop your own questionnaire, but a court is trying to make you go to trial. So these the last 4 pages of this questionnaire to me was important. One, have you received your COVID test? If so, when? Have you requested to be tested for COVID and been denied a test? Have you or a close friend or family member had COVID? Who and when? And that's important, not only for you, but also for the safety of the other jurors, because you don't want anyone that's, I guess, supposed to be quarantining or has a family member that's suffering from COVID, on your jury, because if they can't fully focus on your case during the week or however many days your trial is going to be going, that's no benefit to your client. Just some other questions, and you can tailor this however you want. Have you traveled recently? Which sources do you get the news? Do you use public transportation? Will you abide by the court's rules if regarding social distancing during the trial? Will you inform the court if you immediately become ill or exposed to anyone ill during the trial? And that's important. That's what happened in the last case when I was picking the jury during jury selection. We broke for the day, and the next morning, one of the jurors reported in and said, hey, my wife tested positive yesterday for COVID, and that basically got the trial shut down because he had been within the whole jury veneer and been amongst the other jurors, so he had potentially exposed them to COVID from a transactional standpoint. So in that case, I asked the court to instruct the jurors that, hey, judge, we're going to have to let the jurors know that there's a juror that was among them yesterday that his wife tested positive for COVID, and if that's going to cause them any concerns in serving, and in my case, the judge was good enough to just go ahead and say, I'm just going to call the case and continue it on a court's motion so that, the jurors could be aware of it and go get testing if they need and not have to worry about if they're exposed to COVID or whether they've contracted COVID. And it's just some other questions that you can look at. And Marlo will have this and she'll be great to give it to you guys. And then just some other thoughts, some things about questions about wearing a mask in public. What's their thoughts on wearing a mask in public? And you can get these questions not only deal with COVID, but it also could give you a wealth of information of what kind of jurors you're dealing with, whether you're dealing with some conservative or some liberal or some in the middle jurors, probably in the responses to these questions on this questionnaire that you're going to gather. Personal choice of wearing a mask, why not, when the last time they worked, and that sort of thing. So, and the last question is, basically, even on the the questionnaire that I had in the case I had, it was just 4 questions. But I think the last question is, state all reasons why they don't want to serve on a jury during that trial week. Is important to learn that, because you probably want to know that if somebody has some concerns about serving on a jury during that week due to COVID, it's probably not. You probably don't want to force them on your jury if you can avoid it. Let's see. I'm trying to get to this other questionnaire that I had, and this is just the questionnaire that I used in Iberia Parish. Like I said, it was a lot shorter than the other one. I couldn't get the judge. The questionnaire that I got from the federal CLE, from a federal CLE, but this questionnaire was sent out to the jurors in Iberia Parish, and as I said, it was a wealth of information that we gathered, and it's important in this because it goes back to your Batson issues that we talked about earlier. Your client isn't, your client. The composition of the jury sometimes is really important. So we know that minorities, due to COVID, the CDC, and all the studies that's out there, it basically says that a lot of minorities are in high risk class, whether it's high blood pressure, high cholesterol, heart disease, and that sort of thing. So basically, you're entitled to a fair you're entitled to a fair cross section of your jury. So you definitely want to point these issues out to the court. And I would say any questionnaire. I didn't have it on this questionnaire because I didn't. The judge wouldn't allow it. But I think it's important in any questionnaire you do. This questionnaire actually had it up here. It asks what is the race of the person, and that's important because if you're raising a Batson challenge or a jury veneer composition, you definitely want to point out to the court that, a lot of people have been excused prior to coming in jury selection of a minority descent, and that, your client's not going to have a fair trial based on COVID and people being unwilling or unable to serve due to COVID. So you want to make a record of that in case, the verdict doesn't go your way. If the judge doesn't, grant you relief and say, well, I'm not going to force you to try a case right now, you definitely want to be able to point that out. So I believe any questionnaire you have, you definitely want to talk about race. And in this questionnaire, we talked about high risk and, who's high risk and why, and you had to list it. And some pushback you may get from your opponent or the opposing counsel is that this information, in my case, I think I had some pushback where they were saying that it was a HIPAA violation for the court to ask that. My position was that it wasn't. We were basically asking the jurors for this information to provide to us, and this wouldn't be made public, and that we would keep this information under seal after we gather it. So it's important that you get this information. I think it's important that you also ask, if the judge grants you the ability to send out the questionnaire, that you ask the judge to provide you with the questionnaires in enough time. I would say at least a Friday before a Monday trial, so you and your trial team could review this information to make some determinations as to how you're going to approach the jury trial that you're faced with. You got any questions, Marla? I think I saw one or something. Marla? Okay. So that's COVID-related issue. There's a bunch of other issues that you can raise and litigate. I think one good resource, and this is just the case law on the jury composition. There's some arguments that you're entitled to under the Constitution a fair cross section of the jury veneer in a particular parish or a particular place where you're having a jury trial. So you need to look there and make your arguments, and just inform the judge and the prosecutor when you're making is that, if there's a violation, there's an automatic reversal. If there's, some cross section, if there's a systematic exclusion, and you probably can make an argument that, if the judge somebody answers your question there and says, well, I'm high risk, and there's no follow up with it, and the judge, just automatically excludes those people because he finds that they're high risk. I think you can make an argument that there's some exclusion of some good potential jurors, and and you have to make the argument. Well, let's say if a judge excludes, or the prosecutor recommends that the judge excludes some minorities because they're high risk, and doesn't do it for some majorities. You have an argument that to be made that this is a systematic exclusion. And also just the makeup of your jury, you want to definitely attack that if you can, and probably use some of these rules that deal with systematic exclusions. You can make an argument and just let them know that, hey, this is an automatic reversal. If you want to do this kind of stuff, we're going to get a new trial, and if you want to go forward, hey, let's go, but I don't mind trying the case twice. Some good resources for coronavirus is on NACDL, the National Criminal Defense Lawyers Association. There's a corona resource. There's a link for it. There's a ton of information, a ton of motions, a ton of issues that you can look up to see if there's anything specific to your case that can help you out in raising any coronavirus related issues in your trial. Another new update that came out in 2020, the Louisiana Supreme Court recently took the position in State versus Derrick Harris that a person on post-conviction is entitled to an evidentiary hearing to determine whether or not their trial counsel was ineffective at sentencing. There's actually a new case that I saw this morning when I was actually preparing for the CLE that used this holding in State versus Harris to say that you're entitled to raise a claim of ineffective at sentencing in post-conviction and possibly get a new trial or a new sentencing hearing if your trial counsel, wasn't effective or didn't take a position that, even though there was a mandatory minimum or a mandatory statutory maximum that the court had to do because of the habitual offender bill, that your trial counsel could ask for a deviation or departure from that maximum or minimum if they were able to show some reasons why the court should. And I believe in the Harris case, the young man or the person that got a 60-year sentence for either, possession of a firearm or possession of some marijuana, and the trial counsel did not take any steps to or make the court aware of how they could have depart and not give that person a maximum sentence. In Harris' case, there's two dissents, but the majority of the court held that you can make this claim. Is now a valid post-conviction claim that you can raise, because generally, if you look at the post-conviction statute, you couldn't raise. This was a claim that you couldn't raise, but the court has taken the position that now you can. So there's some good law. If you have a client that got hit with a habitual offender, you may want to look at it and see if you want to raise that claim within the next year from this decision, because it's basically a new rule. And even if your client's outside of his 2-year window for post-conviction relief, you may be able to raise a claim that his counsel was ineffective at sentencing, and maybe get him a new sentencing hearing, or maybe get him a time-served sentence, or what have you. So we'll talk about the legislative updates. It wasn't a really busy session this session due to COVID. From a criminal justice standpoint, I basically picked out 3 updates that I think are important. There wasn't, like I said, there wasn't a lot. I don't think much happened even at the special sessions in regards to criminal justice. So the first one is the House Bill 67. It dealt with battering a police officer It amended revised statute 34-2 to include a sentencing enhancement for your second offense. So if you get a second offense, or generally it was, if you got a first offense, it was a misdemeanor, punishable up to 6 months. But if you get a second or subsequent offense, it now comes with some, now becomes a felony, and it also has a mandatory minimum attached to it. And it has not less than 1 year, and not at least 15 days of sentence must be imposed, shall be served without benefit of parole, probation, or suspension of sentence. So now it's some rollbacks of the just and reinvestment package that happened back when Governor Edwards took office. This is one of the rollbacks where now if you get a second conviction or subsequent conviction of battering a police officer, you could be looking at up to no less than 1, no more than 3 years, and a 15-day sentence. There is also Section B that also goes into it, that if the battery against a police officer requires medical attention, and the second or subsequent violation of this provision, you shall not be fined more than $2,000, and you shall be in prison with or without hard labor for not less than 2 years and no more than 5. And you have at least a minimum sentence of that you have to serve in jail is 60 days now. So it kind of gives a mandatory minimum, which we don't really like mandatory minimums if you can avoid them, but this is one of the new laws that went into effect August 1st of this year. House Bill 434 basically created a felony manslaughter rule, and it goes into it now that even if a person if a person is now engaged in a crime of violence, and part of that crime of violence leads to the death, where it's foreseeable that the offender's conduct during the commission of the crime will result in death or great bodily harm to the human being, even if the offender had no intent to kill or inflict great bodily harm. So it basically commits a felony manslaughter rule now. We've always kind of had the felony murder rule, but now we have the felony manslaughter rule. And this is in direct, response to the shooting that if you follow the news, there was a shooting on Bourbon Street a couple of years ago, year before last, or 2 years ago, where some guys had a shootout on Bourbon Street. They were shooting at each other, and they actually missed, and they actually shot an innocent bystander. And this law is in response to that we now have a felony manslaughter rule. This goes into more of the felony manslaughter rule, and basically there's an official comment. There was a case, State versus Garner, that we used to use the agency theory for a person to avoid responsibility, but this kind of closes the gaps that State versus Garner had. So you can no longer use that the agency theory. So it's basically whereby the individual, you're liable for something and you didn't have intent. It goes into that for you to see it. House Bill 450 amended the simple burglary penalties. And this was in response to, this bill was actually, I think, authored at the request of the district attorneys and the district attorney in Orleans Parish, Canizero, where, and I think it's going to target mostly children that break in cars. So basically, it creates a mandatory minimum for a crime that's not even a crime of violence. So now if an offender commits a simple burglary and is armed with a firearm or arms themselves with or possesses a firearm, the offender shall be in prison with or without hard labor for not less than 3, no more than 12. This creates a mandatory minimum, like I said, for a crime that's not even considered a crime of violence, but now you have a mandatory minimum on a non-crime of violence. And this is another rollback of the just reinvestment package that Governor Edwards signed back in 2012 or 2013, I believe. 2015 or 16. Like same thing. I think this bill is going to basically target teenagers who break into cars, and it's going to, unfortunately, subject them to mandatory minimums if they, have a gun, or while they're in the car has a gun, and they take the gun out of the car. They're going to be facing a minimum of 3 years now as a result of this new bill. And that's pretty much the presentation. Like I said, it was a pretty slow year. We have about 15 minutes if anyone has a question. Marla?
Anyone have any questions? Okay, in the meantime, what I want to do is share my screen for those of you who who may be having trouble with the Zoom links. I want to go through this so we can troubleshoot a little bit. Let's see.
If they got a question about criminal law, any question about criminal law, even if it wasn't something that we covered today, I'll be happy to answer if I could.
Okay. Okay, so this is our platform that all of you have received emails for regarding, and we'll get to you. Mr. Armistead has a question, Harry, after I finish with this. This is the platform that you all are logged into. And so when you log in, you're going to see my courses and view course. And then you will see the SULC end of year CLE. And under each day, we have the session and the time of session. So you will just click on the session. And let's go from Lessons from a Young Attorney. You'll click on here, you'll go to the Zoom link, and it will take you to join a meeting. You'll type in your name and hit I'm a robot. On some of your computers, you will have to either launch in the platform or launch externally. If you try to launch in the platform and it takes you back to this screen, click on launch externally, and you should be able to access the Zoom meeting by launching the window externally. If you are not able to access your next scheduled session, please send me an email so we can do it, because sometimes I get multiple calls and I'm not able to answer the telephone because I have multiple calls coming in. But if you send me an email, I respond back to your email very quickly. So I'm going to stop sharing screen, and then Harry, you can get to your questions. Right there's in the question.
I think somebody had their hand up. I think, what was it? Mr. Alvin, I think, had a question. Alvin Armstead. I guess, can he type it, or maybe unmute him, Marla, so he can answer his question?
Unmute. Can you hear me now?
Yeah, we can hear you.
Have they done anything to change the expungement laws? Because it's a nightmare sometimes.
They haven't. I'm unaware of any this year. There was, I think, a bill that was supposed to go, but it didn't make it didn't go to the floor. So it may come up next session in March. But last session it was changed a little bit, where if somebody got a first offender pardon, they may now be eligible for an expungement. So I guess maybe if you can tell me your issue specifically, maybe I can.
I had a client that was falsely arrested and the charges were dropped. And we're subsequently jumping through haymakers trying to get it a simple, just the arrest expunged. Did you hear me?
I say, in your case, the charges were dropped, and you're saying you're having trouble getting the expungement?
Yes. We're required to do basically the same thing we would do on another client that I had that actually pled guilty under 893, and then we had to go through all the paperwork. We got that one done. We're basically having to do the same thing again, pretty much.
So unfortunately, that's the issue, is that even though your client, if the charges are dismissed, your client still has to go through the same process, which is unfair to your client to be, I guess, be falsely accused and then sometime have to pay those costs. But I think there is a mechanism that you can ask the prosecutor to waive those costs. But in my experience, even if the prosecutor waives their costs, state police, in my experience, in cases even when I got the state to agree to that no cost is due, when state police would always call us and request their $250, even if the charges were dismissed against my client. Even though the law says that the DA can move that, state police, still wants their money, in my experience. But I think in order to deal with that, you may want to, if the prosecutor waives the cost, you may want to just move to set it for a hearing, so state police could be present when the judge orders that the cost be waived, and you get a court order saying that, hey, state police, you still have to waive those costs because they're going to want to get paid irregardless of the state moving to dismiss their.
My cousin all the way from Miami, he was just passing through.
Yeah.
Got to drive. I mean, it's just a nightmare for a guy in Miami that has no other dealings with Louisiana at all.
Yeah, so that's an unfair reality that we're dealing with. But hopefully, there's some changes coming to that. Hopefully this session, but not sure what changes exactly. But I would say you may want to contact JAC out of New Orleans. They're a nonprofit organization that JAC, and I think Adrian Wheeler and her crew there could probably answer any expungement question that you have. And they have a bunch of forms, and they can probably, maybe help you navigate some of those difficulties you're having with a client out of Miami obtaining his expungement for a false arrest.
Okay, thank you so much.
You're welcome. I think we got another question, Marla. I think somebody asked is, any updates of inmate rights with regards to COVID-19 safety within a prison? JP, I'm unaware of any. I think DOC has taken the position that each jail is to come up with their own, I guess, procedure and policy dealing with COVID-19. So there's no updates yet, but there may be some this session. I'm not sure, but as far as I know, that's all they have.
Does anyone else have any questions?